Sunday Standard carried a headline, "The weakest link to criminal prosecution in this country, to the fight against corruption, is the Office of the Director of Public Prosecution." I have been given instructions by Sheria Mtaani to take that matter to court, not to sue the newspaper, but to sue the weakest link to the fight against corruption in this country, being the office of the EACC. One, before 2010, before the 27th of August 2010, the office of the ODPP was a branch under the office of the Attorney General. The police were the prosecutors. Kenyans spoke loudly, completely, and said a prosecutor cannot be an investigator. And Kenyans created the Office of the Director of Public Prosecution under Article 157, which gives the officer sitting there a constitutional tenure of 8 years. That office was clothed with clear instructions that nobody can direct the Office of the Director of Public Prosecution on what to do in terms of prosecuting and approving charges. The Office of the Director of Public Prosecution developed guidelines to look at the threshold, the evidence that is being brought by investigators. Does that evidence satisfy the threshold for a conviction in court? Out of this, very many files that are being presented to the Office of the Director of Public Prosecution have been rejected because they don't meet those standards. The Office of the Director of Public Prosecution approves charges, all of them, the whole country. The DCI sends almost 94% of all the files. The DPP looks at are files coming from the DCI, the whole country. The General Police, that is the OCS, the JDs, General Duties, account for around 5% of those that come. KRA, KWS, and other investigative agencies account for around 2%. EACC has a 2% portfolio of the files that go to the Director of Public Prosecution. Out of 98% of the files that are forwarded to the DPP, you will hear no noise from IPOA, you'll hear no noise from KWS, you'll hear no noise from Kenya Forest Services, you'll hear no noise from the DCI, neither will you hear any noise from the Inspector General Police. What is the biggest problem in the fight against corruption? The law is very, very, very settled that before you arrest, you must have gotten approval from the DPP to arrest, so that you are arresting somebody to take him to court. EACC, a complaint is launched. After 2 to 3 days, they'll carry media, go and arrest a governor, go and arrest a member of parliament, go and arrest anybody, drag him to the offices of EACC. Statement has not even been taken by the complainant. Then that person is taken to Kilimani police station to stay overnight, then is released on EACC on police bond. The investigation will take a minimum of 6 months. The investigations of EACC normally takes 2 to 3 years. Then the file is sent to the DPP. The day the file is being sent to the DPP, EACC will call a press conference and say, we have forwarded 400 files to the DPP. Today is Tuesday. On Friday, the EACC will say, we have not gotten a response from the DPP. The investigations took 3 years. The DPP must look at every file, analyze the evidence, then make two things. One, tell the EACC, go and cover these areas. Or approved charges, arrest and charge. The DPP has, I've said, 98% of his work from other investigative agencies, not only the EACC. So the noise we are seeing is purely calculated to depict the Office of the Director of Public Prosecution as not working or as being the impediment towards arresting and charging people. The questions I push to the EACC and in the petition we shall be filing through Shadrack Wamboi and Sheria Mtaani are: one, what is the conviction rate of the EACC? So that we know the amount of resources government, the citizens are pushing there. What is their success rate in terms of conviction? Number two, they have raised issues that the DPP withdraws matters. Every year, the DPP files a report, an annual report to Parliament. And from the report, the media can check every year, the whole country, a minimum of 3,000 files are withdrawn every year. There's a year they withdrew more than 5,000 matters. Why? Article 157 allows the DPP to review files. And the review can be occasioned by the lawyers, the defense team, writing to the DPP and saying, these are the facts that the investigator failed to have. Relook at that file. The DPP can relook at that file and terminate and request to withdraw that matter. Article 157, Subarticle 11, allows the DPP on his own motion. As the case is progressing here at Milimani, the DPP who is in court can look at the witnesses, how they are coming, and recommends a review of that file. And the review can come out that it complies with Article 157.11, that the DPP as the custodian to ensure there is no abuse of criminal justice system will apply for withdrawal. The third issue, and this is very, very critical to the whole country, the DPP has no power to terminate any criminal matter. Let us be very clear. The DPP has no power to terminate a matter in court. What powers does the DPP have? The DPP will review the file. He will come to the presiding magistrate, presiding judge, make an application to be allowed to withdraw. Give reasons. It is the court that withdraws. Under the old constitution, there was what was called the nolle prosequi, where the DPP could walk in and terminate the matter. Today, a matter will be withdrawn with the leave of the court. I think that's 157.8. With the leave of the court. The DPP does not sit at his Ragathi house and terminates or withdraws any matter. Any matter must be withdrawn with the leave of the court. So this narrative that the DPP has been withdrawing matters left and right is not true. The matters, some of them, the media here, you'll look at your records and you'll find some matters the DPP, the courts have rejected the application for withdrawal. And the DPP has been told, proceed. It's not the first time. The DPP aggrieved has gone to the High Court. He's lost. The DPP has gone to the Court of Appeal. The final decision on who this matter will be withdrawn does not rest with the DPP. It rests with the courts. Another very critical issue is the question of the DPP's powers to decide not to charge. An investigator like EACC, an investigator like the DCI will bring a file. Pole, they do not have the power to decide who to be charged. I know very well, and it is in public knowledge, that the DPP, the EACC has been fighting to have powers to prosecute. Any first-year student like these ones here knows very well that an investigator cannot be the prosecutor. Neither can an investigator be a judge. Montesquieu provided for separation of power. The EACC can never, will never, and shall never in a modern democracy be allowed to prosecute. That is the role, a preserve of the DPP. And it cannot change because the best practices worldwide, prosecutors are independent. They make their own decisions, they prosecute their matters. So members of the fourth estate kindly inform the EACC that they will remain an investigator, just like the IPOA, just like the DCI, just like KRA, just like KWS, just like any form of investigator in this country. And therefore, an attack on the office of the Director of Public Prosecution is baseless. There is no evidence at all to do what they want to do. We know a few petitions have been filed to the Public Service Commission attempting to remove the Director of Public Prosecution from office on flimsy grounds. All those petitions, around 8 of them, have been dismissed because they are asking the DPP to be removed from office purely for exercising his mandate. His mandate is to charge, and anybody aggrieved that he has been charged, the Judicial Review Division of the High Court is created for you to challenge the decision by the DPP to charge. Those petitions have been dismissed, and we expect many will be filed, but the position is very clear that EACC to up their game, they do proper investigations, they give the DPP sufficient time, all those files, and we challenge any file that the DPP has told them to cover some areas. Can they bring evidence that they have covered that file and return to the DPP for the DPP to take action? All those files go to the EACC and they are kept there. So it is our conviction that the weakest link and the conveyor belt for corruption is not the office of the DPP, but the office of the Ethics and Anti-Corruption Commission. Thank you very much, unless there are questions to be asked.
So, under the Constitution, it is only the DPP who can prosecute, and not the EFCC, the prosecutor.
There are two functions exclusive to the DPP. One, to decide to charge. Investigators don't have the constitutional mandate to decide to charge. That is the DPP. Two, prosecution. Only the DPP has the power to prosecute. And the DPP, when I talk about the DPP, is one Renson Igonga. Any other prosecutor acts in court on delegated authority of the Director of Public Prosecution. Only one person. The Constitution gave one man or one woman the office to prosecute. Other prosecutors, who are around 2,000, 3,000, act on delegated authority of the DPP. So EFCC can never touch that. And the DPP does not take instructions. It is actually him who gives directions to the Inspector General of Police and all investigative agencies.